So thank you for that introduction. First, I'd like to thank the Center for South Asia and everyone associated with it for inviting me to speak. It really is a privilege. I've had enormous support from the center for my heavily archive-dependent research, and I'm truly grateful. I was an audience member until last week, and so it's kind of like strange being up here. And also I discovered while socializing last week that if you've made it from the audience to the podium, you've quote-unquote made it. And so I have a friend in Madison, and I went to see her last week, and we were discussing this upcoming talk that I was going to do. And she had a friend there who apparently is a regular member of the audience. I actually don't see him here, but so his reaction was something like, "Oh my God, you're the next speaker? That's amazing." So I thought, well, so here I am. So what I'm presenting is essentially an overview of my dissertation with an emphasis on certain aspects that I'm currently writing or reading about and putting together. So it's work in progress, most of it. I usually don't use PowerPoints, but I thought visualization would help, and also put together like a couple of maps and some outlines. So I will go through them as I kind of explain to you what they're all about. So the first one is basically British India, which is now divided into several post-colonial states. And I'm sure most of you know this. And also this is kind of an empire-wide map. This is from the 1920s. Let's see. So this is essentially kind of at the heart of my dissertation. The post-independence countries that I've shown you in the previous map, by and large, have written constitutions, and their governments are assumed to be constitutional democracies on the basis of separation of powers, right? So three-branch government. So this is assumed to be fundamental to preserve rule of law in societies. So the expression government of laws and not men comes to mind. So rule of law promises the restraint of sovereign power. It's guaranteed to bind government to law and keep tyranny and authoritarianism at bay, is arguably rule of law's most compelling claim as a public good. So within this scheme, my dissertation focuses on the judiciary, which is like the far end, that little triangle. It's a simplistic presentation in terms of diagrams. So I'll just give you a timeline. Again, simplistic timeline in the interest of time. You had the Government of India Act, which was the sort of latest consolidation of governance and constitutional schemes that were put together in law, and these provided the blueprint for provisional constitutions in the post-colonial states, so India, Pakistan, Sri Lanka, etc. The Supreme Court that was established in India and later in Pakistan was formed on the basis of the federal courts that was there before, and sort of in the formula of the federal court and the Privy Council. The Supreme Court was then constitutionally empowered to issue directions and enforce fundamental rights, and this model was by and large followed across the subcontinent. So to ensure independence, most of these post-colonial states adopt certain similar measures, right? So within the judiciary, they fix age and tenure of judges, and they make specific provisions for removing judges if the need arises. And rules about appointment and so on and so forth. So another thing that continued was the civil service or the judicial service. And that became the Indian Administrative Service, and in Pakistan it became the Civil Service of Pakistan. So independence of judiciary has long been a controversial issue in South Asian legal discourse. In South Asia, the judiciary has reviewed and ruled against state transgressions, declared amendments, constitutional amendments, unconstitutional. That would never happen here in the United States. You would not review constitutional amendments. And also, there are sort of cases where the judiciary declared its own administration of how it should appoint, how it should run the judiciary free of executive interference, and it set appointment guidelines for itself and so on. So most legal scholarship recognizes that much of the consolidated colonial legislation carried over in the new period, right? So after the British left. But in general, most of the literature that's out there, with a little nod to continuity, it generally assumes that constitutional moments and the birth of institutions coincide. So this assumes a narrow conception of the court, which means that constitutional antecedents only go as far as moments of reform or kind of these historical ruptures. Now, given the historical emergence of law in India, the idea of judicial independence is seldom discussed with reference to history. We think of the doctrines and of rule of law and or concepts of separation of powers normatively, and histories are written as if this law just arrived magically from England and it was planted in India, and that local agency didn't matter, or it's just silent about local agency. But local agency had a lot to do with how the doctrine of separation of powers came to be applied, established, and legitimized in India, right? And this is at the heart of my thesis, which brings me to the early 20th century India, when Indian agency was arguably at its peak. And that's my primary focus, but I go back and forth in history a little bit. So just bear with me as I try and give you a more detailed timeline. So the judiciary has a long and storied tradition of constitutional warfare, not just in the contemporary period, but going back to the middle of the 18th century. And separation of powers was not simply a transplant, but it was shaped as a result of negotiation and contestation between the British and the Indian agents, legal agents. By legal agents, I mean the entire legal complex, right, legal elites. Which brings me to my next slide. So this is just a very general historical account. The rough timeline says basically that British influence followed by direct rule was nearly 200 years. India transferred under the British Crown in 1857 as a result of a mutiny. And as empire expanded, the reach of law also expanded. The colonial project, which was essentially based on economic extraction, needed legal institutions to realize its goals, right? But colonial rule had several layers when it came to how it came to be implemented. So there were various layers. At the top, you had the crown and the parliament. And then it was initially implemented by the East India Company, who went in as traders and then gradually kind of assumed state control. And then, they were replaced by civil servants. And then, of course, you had the local institutional actors. So with that framework, some more changes in laws. So initially, the intervention began with changes in property rights through the Permanent Settlement Act. To put it very simply, without going into too much detail, is that it settled permanent ownership, and it put landowners in charge of collecting taxes for the East India Company. So that was their source of revenue, and it also led to kind of fixing kind of elite positions, or producing kind of new elites within that sort of colonial landscape. And then as empire expanded, more laws were needed, and various charter acts followed, and then all these consolidated acts started coming in. So in terms of courts, you had, as the empire expanded across sort of 200 years, you had mayor courts, supreme courts, and then high court. And high court, which is an 1861 phenomenon, that was authorized by the crown. So you had these letters patent, and then the authority would come directly from the crown to set up this court. And in terms of administration, the imperial civil service came when the British actually assumed direct control of India. So with the laws, the impact of legal institutions signaled a significant change in social relations. A lot of scholarship looking at legal history looks at, to various extents, at the impact of criminal law, which is extremely interesting. Settling disputes and punishing crimes was certainly one aspect of, and law and order was one aspect of state-society nexus, but the administrative usage of courts and laws is the other side of the story. It's probably the more boring side of the story. But a lot of litigation ensued as a result of this property law intervention. More people had ownership to land, there were more cases, and law also became a source of this upward mobility of elites, right? Elites were produced around the legal system, as a result of the colonial experience. Not everyone had land, so, installing an administrative apparatus of the state, if you like, it required lawyers, judges, civil servants, and so on. So a lot of people who owned land turned to professionalization, and they were also the conduits for connecting central-local relations and rural-urban connections. So to give you a more kind of specific period idea is, I look at kind of British rule in terms of three moments, right? One before 1857, before England assumed direct control. So a three-branch government, the way in which it emerged in Europe, based on checks and balances, looked very different in India. Institutions that emerged in British India protected the interests of a distant monarch with a view to consolidate power and accumulate wealth through the colonial project, right? So it was also arguably the product of power struggles in England over the misadventures of the East India Company and consequent transfer of governance to the crown. So that was up to 1857. After 1857, but actually I should make one point here. So 1857 is when the mutiny was, but leading up to the mutiny there was significant discontent. So people were already unhappy with the East India Company, and this was already beginning to be recognized. East India Company had already profited from India for a century and enriched England in return. But back home in England, their accumulations were also producing new elites in England. And what many saw as the poisoning of public life. They had a monopoly in British Parliament, or a perceived monopoly at any rate, and a series of reforms were initiated, and the company's governance was also reformed. So the corruption presented by the company had to be remedied, right? So this was already under discussion. And until the mutiny, it was beginning to be recognized. So I'll read out some testimonials from English lawyers and judges on what they thought of natives coming into state administration and Britain having more direct control. So here's one testimony. There's three testimonies. One lawyer says, the great argument which has been alleged against entrusting the natives with the exercise of any extensive judicial authority is their proneness to corruption. Then someone else says, I'm of the opinion that the natives, in respect to integrity and diligence, may be trusted with the administration of justice. I would not commit exclusively to the natives any branch of administration of justice on a large scale. I think we ought to keep the judicial branch to ourselves as a sacred deposit to raise ourselves in the estimation of the natives. Let our judicial character counteract the evil impressions created by our financial system. So, and then the last one, again, it highlights the fear of Indians, right? So the natives are depressed and humiliated, being confined by us to subordinate and servile offices. Although their education is most defective and ignorance and credulity pervade all ranks, especially among the Hindus, they are nevertheless found to acquire easily the requisite qualifications for the duties which we are pleased to entrust them. From temper, habit, and peculiar circumstances, they are in many respects fitter for the office of a judge than ourselves. But we place the Europeans beyond the reach of temptation. To the native, a man whose ancestors perhaps bore high command, we assign some ministerial office with a poor stipend of 20 or 30 rupees a month. Then we pronounce the Indians are corrupt, and no race of men but the company's European servants are fit to govern them. So these are the kind of various opinions about administration that was marked by fear. One other feature of the English Palace Wars, which is the first, these triangles represent, the top of that triangle is basically England, middle is basically like the colonial administrators following commands from the crown, and then this period, and I'll get into it in a second. So after 1857, right, so just in the run-up to the mutiny, one feature of the English power struggles was that the monarch at the time was somewhat hesitant to allow Parliament direct authority over India, because the Parliament was, in many circles, blamed for losing their American colony. So there was that sort of inter-branch struggle in England. But in 1857, they didn't have a choice. The mutiny was there, and they needed to come and assume control of India. They didn't want to lose it. So the crown assumed control, and Queen Victoria's proclamation essentially promised to take care of her Indian subjects. So this brings me to the second tier, where I've kind of highlighted the middle, and so power struggles are now beginning in India. So here what happens is the colonial administrators, or the colonial project itself, needed to tie the colony to the crown in England. But this required entrenching the notion of imperial justice and the monarch as a just ruler, essentially building the legitimacy and the symbolic value of the law. So the transfer to the crown was a defining moment in which there was a need to rebuild the crown's legitimacy. And consequently, they needed law and lawyers for the production of credibility of this project. So civil service was beginning to be Indianized. Lawyers were leaving India to be trained either as civil servants or secure calls to the English bar. So this brings me to the third moment, which is 1905 onwards. By this time, what had happened was legitimacy of law is entrenched, right? Like here at the bottom. So Indians now have significantly more agency than before. And once the symbolic value of law is entrenched, an economy of lawyers flourished, which then challenged the lack of even-handed justice and the lack of self-governance that was promised to Indians by Queen Victoria. In the third moment, the ideas of justice and fairness that were initially used to establish empire were now being used in reverse to claim rights for Indians. So the court and its writ jurisdiction evolved as a site for articulating constitutionalism. High courts became a safe haven to challenge the executive in some instances. The lawyers were so good in the eyes of the British that there were lots of anxieties about how good the lawyers were. So they were essentially saying that they're challenging this rhetoric of rule of law we have placed to establish empire. So now, institutions were faced with this dilemma where, do they affirm the colonial project or do they kind of affirm the liberties that the rule of law promises to the subjects? So just a footnote here, I don't explore beyond 1935 because, as I mentioned earlier, it's widely acknowledged that the Government of India Act of 1935 continues in the post-colonial period. So I kind of stop there in my research. Early 20th century, however, was all about consolidation, and it resulted in large-scale constitutional reforms. So it wasn't one document, it was kind of a gradually kind of expanding document that was coming together. So much of these reforms, so every 10 years you'd have a big constitutional reforms, 1909, 1919, 1935, so almost every decade or so. So much of these reforms were often concessions in response to social movements, nationalist protests for greater representation, and increasingly escalating Hindu-Muslim conflict in undivided India. Now, although a lot of these reforms, I don't want to overplay these reforms too much because they offered some concessions to Indians, right, in the form of greater democratic representation, but for the most part, it actually solidified executive control. The British were kind of challenged in their continuous rule of the colony. So this takes me to the next slide, which is what did judicial institutions mean at the turn of the... So everything I refer to now is pretty much the early 20th century India, kind of jumped forward a little bit. So the long history of judicial institutions in India revealed their functions, that these functions expanded in tandem with the colonial project. These institutions, in one sense, were brought in to appease the elites. As long as landholders and other elite members brokered between the poor and the colonial masters, one could, and these elites could be assured with guarantees of justice, a revolution could be avoided. A professional class of lawyers which emerged in the 18th and the 19th century expanded around this heavily bureaucratized legal complex. This expansion was needed for realizing the goal of legitimating the Crown's authority on the one hand, but it was also enhancing status of the actors who now had found in these legal institutions a means of mobility. And this was not attached to land ownership. That was traditionally the way of kind of accumulating wealth. So at the turn of this century, the judiciary is understood to have dual functions. It had vertical as well as horizontal functions. Horizontal relates to preserving institutional independence vis-a-vis the other branches of government, right? So judiciary has kind of a policing role, checks and balances. The vertical function refers to maintaining professional efficiency, which means that the High Court supervises the lower courts and carries out other administrative tasks. It's not that the executive and the judiciary hate each other, far from it, but their normative functions collided with what was happening in practice. So I will look at the judiciary through actors like lawyers and judges and what was actually happening in practice, right, away from what was the ideal. I should add that I've looked at primary sources, as Anitra had told you guys at when she introduced me. So I've looked at kind of departmental records where officials are talking to each other, legislative and parliamentary debates. I'm just beginning to look at that, and also other judicial policies that impacted British India on the ground. So I connect the three layers that I showed you on the triangle, which is the Crown, and then the colonial administrators, and then the local agency, right? How did those imperial policies look like on the ground? And my case study to do that is Bengal, which is sort of present-day Bangladesh and part of India. And to do this meticulously, like, I would have to be specific, which is why I chose Bengal. I mean, otherwise I think an all-India-wide dissertation would probably result in myself and my supervisor growing very, very old together in Madison. So I chose Bengal also because of a lesser-known history of Indian resistance to imperial rule. Now, 1905 is an important moment for the nationalist project because it marks the first partition of Bengal. The viceroy actually just decided to split the district administratively, right? And the lawyers had issue with that, and this was articulated in constitutional terms, and actually the partition was reversed. The protest went on for some 5 years, and it was reversed. Now, it's not that it's lesser known; it's more known as a social movement rather than a constitutional movement. But it was very much a constitutional movement. In fact, many of the demands that Gandhi makes in his campaign in the 20s were part of that 1905 campaign, almost in similar terms. But unlike Gandhi rejects imperial rule, whereas the lawyers in 1905, they very much adopt the law to articulate their demands. So moving on, coming back to judicial functions, horizontal functions, structural reforms that take place after 1857, like the High Court, including Indians in civil service, it led to novel institutional tensions, right? Because now these institutions have expanded. So in the Company era, the Supreme Court, when the Supreme Court was around, the Crown's agents drew the ire of the company officials. They did not like to be policed. In the new era, the civil service was a necessary part of empire. But for some reason, the civil service enjoyed more of a higher status than those servants that were part of the judicial service. So there was status competition between the two sort of cadre of officers, if you like. English language was a marker of status. It became a contested issue. The use of English was commonplace among civil servants. Now, formerly, executive magistrates heard appeals in district courts. But with the expansion of the judicial service, new officers who were trained in sort of law were coming in, and they were part of the judicial service. So when they were going to assume the same duties, there were various disagreements among the judges, and much of these centered on the capacity of the native officials who were well versed in the vernacular to hear appeals in English. Now, one judge even quips about the preposterousness in the assumption that the executive officers, some of whom were also native, were somehow superior in the capacity to deliberate in English than those in judicial service. So this was an internal conflict between the two branches. Secondly, local disputes became the site for airing out interbranch tensions. In one instance, a magistrate ruled, so this is a local dispute, right, in one of the districts in Bengal. So the magistrate ruled the construction of a roadway inside the court compound illegal. So what had happened in this case was that you had the court compound, and some 10 years ago in that district there was an earthquake. And the result of that earthquake was that there were certain damages to the building, so the court moved kind of next door in the adjoining compound. So after 10 years, this was never repaired, but the property began to be used by locals. One of the older buildings started getting used as a makeshift school, and the road that cut through the court and the town was beginning to be used for public access. So the district judge one day decides that this right-of-way is illegal. People can't use it, it belongs to the government. So when he declared this illegal, it led to agitation in the local bar because the local residents complained, and a case was filed against this judge. So what had happened was that when the case is filed against the judge, it goes to the collector to be decided. So the executive is essentially making a ruling whether or not the judge was correct in what he had ruled. So when the judge's position was that I was trying to protect government property, but the collector who hears this case rules against him and says, actually, no, this is unconstitutional. You can't do that because only we can decide if this land is legal or illegal. And it didn't come across in government surveys, so essentially the judge's ruling was illegal in this instance. The judge in internal departmental records expressed his dismay at what he perceived to be a betrayal by the state, because he said, well, I was trying to protect government property, and this is how I'm treated as a result. So another incident relates to a survey that the Revenue Department was carrying out, and the government needed to acquire land and dispossess certain local landholders. So there was naturally local outrage over this, and there was tension with the government as this process was taking place. So there was pressure on the judge. So cases were filed in the local court about the propriety of acquiring land. And there was pressure on the judge from the government officials not to rule opposing what the government was doing. And he had letters sent to him, and he was approached and said, if you do this, what you're basically displaying to the locals is a disunity between the branches. We are supposed to appear as one unitary state. And you can't make this ruling because if you do, it's going to lead to further outrage and we're going to lose control. But anyway, this was reported to the Calcutta High Court, and eventually the judge ruled against the government. So the third incident relates to a criminal case. These are just some examples that I'm using to display the tensions. So the third incident relates to a criminal case. The criminal case arose from a land dispute. There was a case pending in one of the courts over a piece of land. Two parties were disputing over it. The party in possession eventually made a police complaint that certain suspected associates of the other side entered his land and stole his crops. So the head of police, one Mr. Lyle, happened to write in the report that he was sending up to trial that the accused did not appear to be bona fide. Now, that is imputing blame on the accused, and police are supposed to conclude their investigation and send it to trial. So by trial stage, the same person who wrote this report, this Mr. Lyle, has been elevated as the magistrate, so he got a promotion. And what that would mean is that he would try the accused. So the accused asked for a transfer. And what had happened was the High Court reviews this, and as the High Court is considering whether or not to transfer the case, this Mr. Lyle pleads to the High Court that you can't do that because this will have serious consequences, because it would impute impropriety on part of the police. It would say that the police actually collaborated or are corrupt or that there was significant bias, right? But English justice needed to be and English law and order sort of needed to be represented as just. So the High Court went ahead and transferred the case anyway, because they did not seem to think that this policeman who had made that statement would be able to try the case with sufficient degree of independence and impartiality. So eventually it was transferred. So a lot of these incidents point to this growing concern over the non-cooperation between the two branches of government. As late as 1908, cooperation between the executive and the judicial officers remained an important issue for the High Court, right? It was constantly trying to mediate between the two branches. So this brings me to the vertical functions of the judiciary, right? So horizontal, interbranches, vertical, basically High Court, and all the subordinate courts beneath it. So the court's own internal administration was inconsistent. The Calcutta High Court often voluntarily gave up administrative authority to the central government. And it also deviated from its own rules, right? Even though the approach was very much, we're very strict about the rule of law, but there were always these little deviations in practice. And finally, when you look at the sort of hierarchies within the court, there were racial and class-based hierarchies within the recruitment policies, which appeared normatively neutral, but they were discriminating in practice. So the Calcutta High Court's request for administrative support, resources for judges and so on, these were generally directed to the central government. Many non-judicial administrative posts, like the registrar, for instance, these were absorbed and regularized in the civil service as opposed to directly being recruited by the High Court. The court just did not want to deal with administration. They just said, you guys absorb them in the service, and we don't want to worry about it. So many of these posts under civil service regulations were reserved for Europeans who were at least 25 years old. But it was very difficult to find 25-year-old Europeans with the kind of experience needed for carrying out the role of the registrar. So sometimes, on many occasions, it was commonplace to recruit older and more experienced Indians. But this was predominantly an exception to the rule. Like this was not in the civil service rules. So these deviations remained largely unproblematic until changes were proposed for the High Court Act in 1931. The government proposed that the Chief Justice of the High Court would be selected from both the bar as well as those from civil service. Now, this post of Chief Justice of the High Court was reserved only for those judges who came to service through the bar, through practice, and not through civil service. Now, lawyers, this is still a problem because there's still a two-track appointment to the judiciary. And so the lawyers viewed this as an attack on judicial independence and an effort to recruit a government loyalist into the high office of the Chief Justice. And the court was important to the lawyers. So the lawyers launched this nationwide protest. And from a rule of law perspective, both the judicial and the administrative appointments were problematic. But it seems that once the bar's interests interacted, right, there's a direct attack on the bar, and the court's important for the bar because they're able to challenge the executive in the court, so they needed to protect it, right? And this deviation was articulated in constitutional terms. So, moving on, the High Court's supervision, as I mentioned, there were sort of racial and class-based hierarchies. And you see this in the ways in which the High Court supervised the lower courts. This showed class-based hierarchies in the manner in which the lower-tier staff and officers were treated. They were sometimes treated with distrust and at other times treated with paternalism. One incident in a Bengal district is a good example. So it's a story where there was a fire in the courthouse and a large part of the compound absolutely burned to the ground. It was completely destroyed. The incident was reported by chowkidars or watchmen who was in charge of looking after the place, and the investigation began. So once the investigation began, the first target were the lower tier staff, right? In fact, the watchman himself. And the watchman, however, was saved because he was very lucky that he had an eyewitness when he arrived at the scene. So once the chowkidar was exempt, the next target were the clerks. And the clerks, basically the investigation cleared them eventually because there was confusion about whether the fire started indoors or the source of the fire was from outside the compound. So the investigating officer thought perhaps the clerks left a burning cigarette and forgot. They left a burning cigarette maybe inside one of the cupboards where the files were. So because of this confusion, the clerks were also, it wasn't conclusive proof that they did it. Then the next imputation was directed at the litigants themselves. So litigants were coming to court for redress because there were certain cases of forgery and a few landlord tenancy, like rent suits that were going on. So they thought, okay, maybe there are these forgery documents somewhere in the cupboard, and one of the litigants came and burned everything to the ground. So there were these doubts, and this was sent to the Calcutta High Court, which then came back with these extensive guidelines on how to keep the court fireproof and also how to vet lower tier staff. So in other instances, this is one example of the first suspicion goes on to the lowest tier staff, and then you work your way upwards. In fact, the interesting thing is they never doubted the judges, right? So it was always either the litigants or the lower tier staff. So in other instances, the Calcutta High Court also took on a more paternalistic role towards the court staff. But mainly, it wasn't that they cared about them so much. It mainly stemmed from their disdain for Indian or subordinate judges. For instance, inspection audits of district courts in Bengal revealed a general practice of the use of process servers, right? So these are the people that go and serve process on litigants. And that district judges were using these people for personal work. And by personal work, I mean manual labor. And some of the process servers were complaining And the audit reports basically were surprised by this practice, and they considered this practice wholly repugnant to English sensibilities of fairness. Now, in both cases, the Calcutta High Court appears to be distrustful of both staff as well as district judges. On the one hand, administrative staff seem to be in need of strict rules of policing for policing their integrity, while on the other, district judges needed to be civilized in English ways of propriety. So either way, I mean, your integrity is questioned. So the court's relationship with the subordinates, whether it's institutional, whether it's judges, administrative staff, it reveals the place of race and class-based hierarchies, right, within the judiciary, and the extent to which legal institutions were not only a tool of governance, but also an arena for status competition. So finally, having looked at the vertical and the horizontal tensions around and in the judiciary, one can see that separation of powers vis-a-vis the court as a jurisprudential ideal was at odds with theories about bureaucracy and the colonial project. So the theoretical strand of my dissertation engages with Dicey, who is considered the father of English constitutionalism, and he considered the rule of law to be excluding the existence of arbitrariness, of prerogative, or wide discretionary authority on the part of the government. Now, this is quite ethno-cultural on his part. He says, Englishmen are ruled by law and by the law alone. It also, in his conception of rule of law, he also excludes the idea of any exemption of officials or others from the duty of obedience to the law which governs other citizens or from jurisdiction of the ordinary tribunals. So this is the ideal, right? So liberty, you need to be free of arbitrary rule. This ideal is at odds with the idea of an administrative state, which was fundamental to the colonial project, right? Colonial project needed a coercive state. So for instance, trade and private contracts. Trade is how the colonial project began. And you needed private contracts. So to execute private contracts, you needed a state apparatus. You needed some coercion, right, for the state to force you to respect private contracts. And so this coerced obedience. So now the father of separation of powers, which is Montesquieu, even he was rejected. You know, when constitutional reforms were being considered for India, people actually expressly said separation of powers is deemed unsuitable for India. Indians are not ready for this. So efficiency and control were prioritized over institutional independence. The colonial power through its institutions also needed to present an appearance of unity that was not at odds with each other. The parameters of an independent judiciary, what it should look like, was not based on a predetermined doctrine, but negotiated and debated by Indians and their British counterparts alike. Ultimately, the judiciary drew its authority and legitimacy from two sources. First, its attachment to the crown. It gave it the status it needed. And secondly, rule of law as a rhetoric, it could no longer be a rhetoric, right? It was being challenged in court, and they needed some remedies. So I see the development of constitutionalism taking place within three strands, and I'm almost done. So one is basically understandings about rule of law. It's very normative, and that you challenge the law by means of law. The second form is the more Gandhian rejection of all things English and imperial. And the third was resistance through violence, right? So I'm focusing on the first strand. Because although I think that the other forms of resistance, it helped the British government in conceding to Indian demands, it was actually the first form of resistance that directed the kind of sort of how law was conceived and how institutions eventually unfolded. So one quick story, and then I'll end right there. One of the strong proponents of constitutional resistance came from someone called Surendranath Banerjee, whose life was spent literally in the shadow of imperial institutions. He was outcasted by his community initially. This is in the 1880s. And so he crossed the sea to get training as a civil servant and also legal training. And he was outcasted by the community because, Brahmins didn't do that. You can't cross the ocean. So as one of the earliest candidates to take the civil service exam, he was nearly disqualified because he calculated his age from when he was conceived as opposed to when he was born. This was common practice, but the English calculated age from when you were born. So then, once he gets the appointment, he was dismissed soon thereafter because he couldn't detect a forgery matter. Now, any English person who would have done this would not have been dismissed in this way. They would have been reprimanded, but he was dismissed. So on his return to India, he made it his mission to use constitutional means to counter his opponents. He became a critique of rule of law through a newspaper he established and became a vocal critique of the court in the ways in which it started applying sort of personal laws and also other administrative rules to litigants. So constitutional resistance had its limits, but it also led to certain articulations of institutional independence. Now, at this point, I believe that the judiciary and the court, as a site of resistance, entrenched a kind of legalism. Everywhere the authorities insisted primacy of law, the rule of law, and it was instilled through reliance on court mechanisms, and generally through the promulgation of laws. Now, colonialism largely justified itself in legal terms, and its battles were frequently fought in the name of upholding the law. Now, to function, you had to not only submit to the factual authority of the colonial order, but also the principles of legalism that underpinned it. So what this resulted in finally was that there was a rigid notion of separation of powers. It was normative, it was ideal, but in this scenario, the courts and the lawyers would oppose the normative idea of judicial independence, but not the practical implications. So I'll just end there. Thank you.